My name is Lynn Van Tassell. I'm a U.S. Army veteran. I'm single. I'm a mother of 3 beautiful young daughters. Once upon a time in Lawrence County, Pennsylvania, I attempted to collect overdue child support for my youngest child from my ex-husband. My ex-husband, being a former college drinking buddy of the judge, had his attorney's fees assessed against me for statutorily protected behavior, all because domestic relations incorrectly certified the certificate of arrearages that I used to procure a judgment against him for the collection of his overdue support. The ensuing sanctions were for statutorily protected behavior, i.e., my attempt to collect support for my daughter from my ex-husband who was overdue and in arrears at the time. My conduct could not be criminalized by a court. Fast forward to a timely filed yet quashed appeal in Superior Court, another timely filed quashed appeal, another assessment of attorney's fees from a different judge who is politically supported by my now ex-husband's counsel, a jurisdictional dismissal in federal court, orders of contempt with impossible financial purge conditions, along with no appointment of counsel, or any inquiry into my financial ability to comply with these outrageous financial purge conditions. This in turn led to the issuance of an order of incarceration, albeit while I was on my latest appeal. The issuance of a bench warrant, my arrest, incarceration, my release on, quote, bail from civil contempt, then on house arrest with electronic monitoring with faked and forged criminal charges on a miscellaneous docket published on the Unified Judicial website, the Pennsylvania Unified Judicial System's website, all by the Lawrence County Adult Probation and Parole with the judge's name on it. This was Judge Thomas Picone. A judgment was awarded from motion court from the order that was on appeal. This was on November 17th, 2011. This is the latest. This has been going on since 2007. A judgment was awarded from motion court from the order that was still on appeal. The order of incarceration and additional attorney's fees were assessed, all without an evidentiary hearing, all from a motion court proceeding. This particular county in Pennsylvania is so misguided and does not follow the rules of civil procedure nor the rule of law. The Judicial Conduct Review Board and the Pennsylvania Disciplinary Board are complete and total wastes of time, as they claim to investigate yet do or find nothing wrong. When I publicly criticize the court for their mistakes instead of correcting them, then they find something else with which to sanction me for. The local domestic relations office and the Court of Common Pleas are endowed with monies from the federal government under the Social Security Act, Title 4D, specifically for the collection and enforcement of support. We're talking millions and billions of dollars that the states receive from the federal government. By receiving these funds, the court and its administrative agencies waive their 11th Amendment right to suit from their citizens. Even under this clear-cut case law, try finding any federal judge that will impose sanctions on a state court. I filed a writ of habeas corpus petition recently in the federal court. Every issue that I raised was completely and totally ignored by the federal judge, and this was a District Magistrate Judge Robert Mitchell in the U.S. District Court for the Western District of Pennsylvania. The federal judge was completely silent on all the issues that I raised in my response to the respondent's answer. The federal judge did not enforce his own order against the state court respondents by making them enter the entire record. He merely dismissed my petition for my failure to state my inability to comply in the appellate court. Yet I can't figure out how he could come to that determination when he didn't even have my briefs that were filed in the state appellate court. Figure that one out. He didn't have any of my briefs, yet dismissed for failure to raise the issue of the ability to comply with the state court orders. It's as though we are living in a third world country where we actually have no rights. What led to these sanctions were, I filed a judgment against my ex-husband back in 2007 using a certificate of arrearages that was issued by the only authorized government agency allowed to do so. They had the wrong amount on it. The court held me responsible for this agency's mistake and incompetence, even though I'm the one that pointed out it was entirely wrong. I told the court and this agency over and over that it was wrong and no one was willing to admit their mistake or to correct it. The court sees this opportunity to punish me, I believe, for advocating on behalf of others and assisting them in representing themselves in court. Successfully, too. I openly criticized the concept of judicial retention in a letter to the editor of the Newcastle News that was published on October 25, 2011. Subsequently, immediately subsequent to this publishing of the judicial retention criticism letter, I was sentenced to incarceration for an order of contempt which was on appeal in Superior Court at 63 WDA 2011. The case had been on appeal since January of the year before, and this happened in November of 2011. Also, I was appealing in forma pauperis in the appellate court. Therefore, I wasn't required to motion the lower court for a stay or post a bond to effect a supersedious. There are numerous errors in this case. First of all, I filed the judgment. Opposing counsel filed a petition to correct judgment. According to the rules of civil procedure, the petition to correct judgment can only be heard before a DR hearing or conference officer in the same manner in which the original support proceeding was heard. The judge heard it in motion court again, no evidentiary hearing, making a ruling with no evidence in front of him whatsoever. He struck the judgment, canceled the sheriff's sale, and remanded it back to DR, even though this is well outside the scope of the rule and his jurisdiction of the subject matter. Each and every order was governed by the Pennsylvania Rules of Civil Procedure 1931 C3-1, which states once family court cases are consolidated, and the judges are allowed to do that. If the parties are the same, the issues are the same, they can consolidate cases and hear them all at once. That's what they did. They consolidated two judgment or DSB cases with a DR case, a domestic relations support case. And they heard all three cases, issued one order. But from the date of the final hearing of the matter, and it could take more than one day, for instance, but from the final hearing of the matter to issue its ruling, the court only has 30 days. None of the orders issued in my case were done in 30 days or less. Therefore, I argued the court lacked subject matter jurisdiction after they quashed my first appeal, and that the orders were time barred. These were also not voidable orders, but already void on their face, and a mere inspection of the record would indicate such. It seems the court is content to break the rules rather than follow them, and there's nothing we can do. As citizens, we're helpless. The appeals court never took up the validity or the legality of the sanctions imposed against me, the jurisdictional nature of the time bar, which made all of the orders void on their face. Every time I tried to bring it up, they just quashed the appeal and assessed more fees. The appellate court actually corrupted the record to make it appear as though they actually went to the issue on one occasion, when in fact they limited the scope of that one appeal they heard to the issue of contempt only, and it said so right in their order. They never once considered whether the court had the power to punish me because I engaged in statutorily protected behavior. They just want to forget about that part. It's as though they've never heard of the federal mandate. I've asked the courts, the appellate court included, to correct the record, cleanse it, make it true and accurate. Absolutely not. I was denied. I asked for emergency injunctive relief. Denied. To this date, I have not had a bench hearing after I was picked up on a bench warrant on November 26th. I'm out of jail, yes, and the court keeps reminding me that I'm making a mockery of it, and yet I tell the judge, I'm not the one that found me in civil contempt but let me out on bail. I'm not the one that faked and forged criminal charges on a miscellaneous docket after ordering that I was being held in civil contempt. You know, I don't need to make a mockery of this court. The opposing counsel, by putting motions in front of you when you don't have jurisdiction to act on them, is doing a good enough job all by themselves. So I've never gotten a hearing on the bench warrant. I was picked up, thrown into jail for 6 days, strip searched immediately upon my arrival. I got out of jail because I worked for the Commonwealth of Pennsylvania. My employer sent a letter to the jail and to my house. My daughter hired an attorney who presented it to the judge. When the judge found out I worked for the Commonwealth, all of a sudden that makes all the difference in the world, so I was sprung. Why? What's the difference if I work for potato sallies or the Commonwealth. I'm still a human being and I did nothing wrong. Anyhow, evidently it was an issue. So my current employer wrote a letter that was presented to the judge stating I was going to lose my job. I was on unauthorized leave. My 3 children were frantic during the 6 days I was incarcerated. All my friends were calling the jail, the county commissioners, the governors, senators, the FBI, and I actually believe it was the FBI Public Corruption Squad who was instrumental in getting the judge to expunge the faked and forged criminal charges on a miscellaneous docket that were found by my employer. These charges were published on the Pennsylvania Unified Judicial System website for all the world to see for 3 long months before finally being expunged. Go look. My name's Lynn Van Tassell. My date of birth is October 1st, 1962. You will not find me incarcerated anywhere in the state of Pennsylvania. I don't know if they are still out there on the web anywhere, but I sure can't find them. I never got an explanation or an apology from the court for how this happened. I cannot believe that I was a member of the United States Army who swore to defend and uphold the Constitution of the United States and the laws of the United States, only to come back to my hometown, raise my kids, and discover that I actually have no rights.